case on this morning's docket, case number 112897, in the matter of Sam S. Kepfield.
May it please the court, I'm Alexander M. Walczak, Deputy Disciplinary Administrator. This is the original case of attorney discipline against the respondent Sam S. Kepfield. A panel hearing was held on August the 20th, 2014. And prior to the panel hearing and at the panel hearing, the respondent stipulated to the factual allegations of misconduct, as well as stipulated to the 4 rule violations, which were scope of representation, diligence, communication, and wrongful termination of the representation. The representation concerned an inmate at Hutchinson Correctional Facility where he was disputing or challenging the retroactive application of amendments to regulations and the application to good time. The respondent primarily practices in the area of criminal law and particularly in post-conviction relief actions. There were no exceptions taken to the hearing panel's final report, so I believe the most significant issue at the panel hearing and before you today is what is appropriate attorney discipline. At the panel hearing, and actually prior to the panel hearing, the respondent submitted a proposed plan of probation, and the recommendation from the respondent at the hearing was that his plan be approved. The disciplinary administrator at that hearing recommended that the respondent be suspended for a brief period of time, 90 days. Following that he be placed on the respondent's plan of supervised probation. The hearing panel, looking at the proposed plan of probation and listening to the evidence primarily from the respondent during the hearing, concluded that the plan of probation could not be approved because it was not placed in effect per the Supreme Court rule prior to the hearing. And so what the hearing panel did was in essence made a recommendation to this court that the respondent be suspended for a period of 1 year. And then after a period of 90 days, that the respondent be placed under supervised probation for a period of 3 years, and with the addition that he comply with 2 additional requirements above his plan of probation, which were to refund the retainer money of $2,000 back to the client, as well as to fully participate in Allianz as well as the attorney support group out of Wichita. Those 2 items, the Allianz and the Reserve Support Group, was reflected in a KLAP monitoring program. And 2 months prior to the panel hearing, the respondent entered a monitoring agreement with KLAP. And those provisions were there. And during the testimony of the respondent, there was indications that he was not diligently attending those meetings. So I believe that's the reason the hearing panel added that to their recommendation to the court. Regarding the monetary requirement recommendation from the panel, at the panel hearing there was a representation that the client died 2 weeks prior to the hearing. So the issue was who to refund the money to, and I believe the counsel for the respondent will talk about that, where the monies actually has now been paid to counsel, and counsel is going to pursue providing that $2,000 to the estate of the client. On review before this court, I contacted KLAP and verified that the respondent is diligently participating in the monitoring agreement. He's fulfilling the terms. He is attending Allianz meetings as well as the Wichita Attorney Support Group. He's also seeing a doctor, and he's being treated for by medication for anxiety and depression. He has a practice supervisor who has conducted a full audit and has provided me an audit report regarding his cases, calendaring, and bank accounts. The recommendation I'm making to the court is that the respondent be suspended for a period of 1 year, but the imposition of that be suspended immediately, and that for a term of 3 years, and that you adopt the requirements of the hearing panel, that is of the respondent's original plan of probation, coupled with the monitoring agreement, as well as the two requirements of restitution of the money which he has done to his counsel, but not yet to the estate, as well as continuing to follow the requirements of Allianz and the Wichita Support Group. And the reason for this is because I was concerned about the gap of 9 months. I believe the respondent, the type of practice he has and the difficulty he had coming up with the $2,000 indicates to me that he has some money is tight, and this will permit him to practice law and continue to practice law, as well as a good, strong carrot for him to abide by the terms and the conditions of both agreements during this three-year period of supervised probation.
Wouldn't it also be the case, Mr. Walczak, that to the extent the panel's recommendation was designed to give him an incentive to implement his probation plan, that has now occurred?
It has occurred.
So you don't need that 90-day of suspended time?
Correct, Your Honor.
Okay, thank you.
If there's no questions, that concludes my remarks.
Any more questions? Thank you, counsel.
Thank you.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. The panel report accurately reflects the facts in this case, that my client took on a post-conviction case, took the money, a retainer, and didn't do the work. There's no doubt about that. The question is, why did he do that, and what was wrong with him at the time, and have we done anything to change that type of behavior? And I think the answer is a resounding yes. When he came to me, we immediately got KLAP involved. And as usual, Ann McDonald and her staff did a tremendous job of working up a plan and trying to get my client to follow the plan. He implemented as much as he was able to, but as the panel indicated, he did not go to the Al-Anon meetings as required. Now, the question you should be asking yourselves, and I'm sure you have, is why? When that carrot is out there, when he's told that he needs, in addition to therapy, in addition to a monitor, the one other requirement, and a major requirement, is that he attend Al-Anon. And the reason, from my reading and from talking to Ms. McDonald and my client, is this. It is so difficult for a depressed person to put one foot in front of the other. They have to start working on their program, and it is a process that takes a long time. And also, I've known him for 20 years, my client. It was difficult for him to come to me and ask for help. It was difficult for him to go to Ms. McKinnon, the public defender, who was his monitor both for KLAP and for as his practice supervisor, and to go to her. They were embarrassed. My client was embarrassed, and it was hard for him to go to the meetings because he was scared of those meetings. And the carrot came through the panel report. And the panel report says, we're not accepting Ambrosio's probation plan because his client, the respondent, is not doing one of the most important requirements. And when he saw the panel report, it was like he was hit in the head, and suddenly he started to work that program. Now he goes to Al-Anon, and I would imagine those first couple of meetings were tough to open up. Now he goes to those meetings, and in addition to going, he's even led the meetings. So it is working. He is working on his depression. Recently, we've gotten a report from the psychologist who has indicated not only does he have depression, he has an anxiety disorder and some type of sleep disorder, and he's been given tools and medication to deal with the depression, the anxiety, the sleep disorder. Not only medication, but given tools how to deal with his sleep problems. The monitor, who has done a wonderful job, and she has worked as his KLAP supervisor. She's familiar with Al-Anon. She's familiar with AA. She's familiar with 12-step recoveries, has done a good job there. And my colleague in the KLAP's office, Ann McDonald, suggested that she also be the practice supervisor. So she's supervising his practice. They're meeting on a weekly basis. They're talking by phone. She did the audit report and gave it to Mr. Walczak so that he knows what's going on. He is really working his program. And I understand that there are many of you and many of us who have never needed to work the program, but we are not depressed. We are not anxiety-ridden. We are not alcoholics. We are not any range of things that occur to the lawyers who you're in front of or in front of you every month. He is working the program. He is putting one foot in front of the other. And I got to tell you, the criminal practice that he does down in Hutchinson is a tough practice. And most of his cases that I've read in the audit report are appointed cases. So he's laboring in the vineyard that most of us don't want to labor in, on those only appointed cases. And he's doing a good job. He has one domestic case, because I don't want him to do any domestic cases. That's a recipe for failure. And that's because he's helping out his mechanic who works on his cars all the time. And then he will do nothing but criminal practice. Ms. McKinnon indicates to me, that's the supervisor, he's going to his meetings. I've received a letter from the head of the lawyers group down in Wichita. These are wonderful groups. We have them in Wichita, Topeka, I think there's one in Lawrence and in Kansas City that deal with lawyers and their problems, especially depression, especially anxiety, indicate that he's going to all of those meetings. And I've got a number of clients in there who will give me a report every so often. He is taking part. They're dealing with his problems. He's opened up. So a fearful man to open up about all the problems that he's had has now opened up. And he's working with the things that led to his failure, miserable failure, and the lack of helping the client in this original case. Now, as to the restitution, it's been hard to come by for my client. After the panel report, he sent, a number of weeks after the panel report, and I can't remember when, $750 we placed in my trust account. Today he has given me the remainder, and I advised my colleague ahead of time that money was coming in today, that I'm to place in my trust account another $1,250 to make it $2,000. That's what he took from JL when he agreed to represent him as a retainer. We're going to forget about what work he did do because it was such a miserable failure that the client's family is entitled to all that money back. I've been in contact with the lawyer for the estate. Now there's a second lawyer for the estate and some problems. The lawyer for the estate said, John, please keep whatever you have in your trust account. And he also said, very seldom we have a situation where people are trying to pay off old debt in the estate, but we will call you, and when we need that money, if you will have it in your trust account and you will send us a check, we're okay with that. So he's done everything that he can to make that now deceased client whole. I've had more success stories with other lawyers who right away gotten back on that bicycle and started doing their program. It's been a little harder for my client, Mr. Kepfield, but he is doing the work now. If he works with the monitor, if he continues to go to therapy, if he follows the suggestions made by the person who did the psychological evaluation, if he goes to Al-Anon, if he works with Ms. McDonald and her staff, he can make it. If he doesn't do those things, he's going to fail miserably, and the depression, even with the medication, will overtake his life, and we'll have more of these things. Without further ado, I'm going to have my client address you, if that's okay.
Good morning. First of all, I'd like to thank John for his, not just his representation of me, but he's helped me in a number of other ways. I will say that being on the other side of the lawyer-client relationship has been a real eye-opener. I'd like to thank Ann McDonald. She's here. She's helped me a great deal. Ms. McKinnon, who is my practice supervisor and KLAB supervisor, has done quite a bit for me, and I'm eternally grateful to her. In fact, she took time out. Her first granddaughter was born this week, and she took time from being a proud grandmother to send the report to Mr. Walzak. Mr. Hebert, who runs the group in Wichita, I have grown to know him and the members of that group, and it has been a real help. I wish I'd known about it a couple years ago. I'd like to thank him for the help that he's given me, and those who wrote letters on my behalf. I thank them, and those who have been in contact with me and provided other support through probably what is the most difficult time of my career. This is my 11th appearance in front of this court, in this room. The first one was in 1989 when I was sworn in as a member of the Kansas Bar, and it was the proudest moment of my career, obviously, and one of the proudest moments of my life. Today marks the 11th appearance, and it is the low point of my legal career. And it's made worse by the fact that it is entirely my own fault. I failed. Mr. Levere, JL, and I am no longer able to express to him my regrets for doing that. I cannot change the past. I can only attempt to understand why this happened and to take steps to make sure that it does not happen again. Likewise, I cannot control the future. I can't tell you what your decision should be. I cannot guide your decision. I can only take steps now, in the now, to achieve a desired result. And I'd like to thank Mr. Walzak for his recommendations as to what that result might be. Why did this happen? I will assume that you've reviewed some of the record from the committee hearing, and it is accurate. I don't need to go into it at any length. I have had this condition for some time, since I can remember. And Dr. Parker's report about the additional anxiety was sort of a revelation, but not a complete surprise. There were issues that in my personal life that were contributing greatly to this. There were issues with my work environment that were contributing to this. I'm a solo criminal practitioner, and that alone is a difficult environment. I didn't go into the practice of law to make money. I sure as heck didn't become a criminal defense lawyer to become rich. Part of the economic difficulties, I'm trying to keep a 23-year-old Honda running so I can make my out-of-county court dates. It is difficult, it is made difficult, and I'm sure anybody who's been in this court for any period of time will know that Reno County is by itself a fairly difficult, if not hostile, environment sometimes for criminal defense lawyers. And during the period in question, early 2013, there were at least two matters that were causing a rather unusual amount of stress. One was a habeas corpus case that I had been appointed to handle as part of a conflict, and the original case had been quite contentious, in fact leading to threats of arrest of the defense attorney. Stay away from it. And the other one was a attempted murder case that I was handling that was also being quite. This is not an excuse. This is an explanation. There is no excuse for what I did, as Mr. Ambrosio said. There was an attempted murder case that I was handling that was also quite stressful. So that's what happened and why. What have I done since then? Well, I've been seeing a therapist regularly. I've kept with my daily routine as recommended in the monitoring agreement. Sometimes I'm too exhausted to exercise, but I usually make an effort to do that. The big part of it, I think, the restitution has been made. So that will make Mr. Levere or his estate whole again. The big problem that the committee saw was I wasn't going to the Al-Anon meetings. And Mr. Ambrosio said there's a very good reason for that. Why didn't I go? Fear, shame, any embarrassment, any number of reasons. Going to that first meeting, I was probably more scared than at any time since I got off a bus in San Diego in front of a bunch of Marine drill instructors. And I think probably those first few meetings, I don't think I said more than a dozen words. I was terrified. To admit failure like that is very difficult. And I'm not a man who likes to admit that he's failed. And that is part of the reason I'm here. I couldn't face my client and tell him, I can't do this. But since then, I have attended them regularly. I've even led them. A couple of weeks ago, I also pushed for them to meet twice a week. And they started doing that. I went to a Thursday meeting. I was the only one there. I did the readings, talked to myself for half an hour, and then closed down early, but I was there because I actually enjoy getting out once in a while. I probably didn't do that enough before this. But this is a process. I mean, I right now am not anxious. I've actually reached, I guess, the state of serenity. I can't control what you're going to do. I can only tell you where I am in this process. And it is a lifelong process. They tell us that we strive to change. We're never perfect. We may have slips, but this is a process that I will have to continue, not just for the next 3 years, ladies and gentlemen, but for the rest of my life. And I realize that. And I'm willing to pursue it because I don't want to go back to feeling the way I did. I don't want to have this happen. I don't want to be here again, at least not in a matter like this. I think the key is knowing why it happened and doing my absolute best to ensure that it does not. And as Lao Tzu said, to know that you are ignorant is best. To know what you do not is a disease. But if you recognize the malady of mind for what it is, then that is health. The wise man has indeed a healthy mind. He says an aberration as it is, and for that reason never will be ill. I don't know how wise I am. Probably not enough. But I am making an effort to become a better person, not just for myself, but mainly for my clients, the people I represent, the people who need me the most. All I can do is ask for your understanding and your mercy when you decide on my fate. If there are no questions, I would thank you very much.
It may not have been clear, we're asking for the 3-year suspension, but instead of the suspension, place him on probation for 3 years. I mean, if I wasn't clear.
With the 1 year suspension.
1 year suspension, I'm
Don't give him
sorry,
any
for
more
3
than
years.
John.
And I do want to say one thing, even though we're out of time. Before we got up, he was more worried about me than himself, and he said, please, John, don't do what you usually do and lose a temper or yell at anybody. He was more worried about me. I think he's come a long way. That's all that we have. Thank you.
Do you have any questions for either counsel? Thank you both.
Thank you.
Thank you all for your arguments this morning. Court will take this matter under advisement. That concludes